I'm reading Georgia versus Randolph, 2006 case in the consent search section. Justice Souter gave the opinion of the court. When police responded to a domestic dispute, Janet Randolph complained about her husband's drug use, but also volunteered that there were items of drug evidence in the house. Sergeant Murray and Scott Randolph for permission Sergeant Murray asked Scott Randolph for permission to search the house, which he unequivocally refused. The sergeant turned to Janet Randolph for consent to search, which she readily gave. She led the officer upstairs to a bedroom that she identified as Scott's, where the sergeant noticed a section of a drinking straw with a powdery residue he suspected was cocaine. He then left the house to get an evidence bag from his car to call the district attorney's office, which instructed him to stop the search and apply for a warrant. When Sergeant Murray returned to the house, Janet Randolph withdrew her consent. The police took the straw to the police station along with the Randolph. After getting a search warrant, they returned to the house and seized further evidence of drug use, on the basis of which Scott Randolph was indicted for possession of cocaine. He moved to suppress the evidence as products of a warrantless search of his house, unauthorized by his wife's consent over his express refusal. The trial court denied the motion, ruling that Janet Randolph had common authority to consent to the search. The Court of Appeals of Georgia reversed. So motion to suppress was denied by the trial court, and then it was reversed on appeal. It held that an individual who chooses to live with another resumes a risk no greater than an inability to control access to the premises during his absence. Quoting secondary source, Lefebvre Search and Seizure, section 8.3, and does not contemplate that his objection to a request to search commonly shared premises, if made, will be overlooked. We granted certiorari to resolve a split of authority on whether one occupant may give law enforcement effective consent to search shared premises as against a, so this is the issue, as to resolve split authority on whether one occupant may give police effective consent to search a shared premises as against a co-tenant who is present and states a refusal to permit a search. We now affirm. So what do they affirm? Do they affirm the appeal court or the trial court? So the Fourth Amendment rule ordinarily prohibiting the warrantless entry of a person's house as unreasonable per se, one jealously and carefully drawn exception recognizes the validity of searches with the voluntary consent of an individual possessing authority. That person might be a householder against whom evidence is sought, or a fellow occupant who shares common authority over property when the suspect is absent. U.S. v. Matlock, 1974. And the exception for consent extends even to entries and searches with the permission of a co-tenant whom the police reasonably but erroneously believe to possess shared authority as an occupant. Illinois v. Rodriguez. So this is case law. You got U.S. versus Matlock and Illinois versus Rodriguez, which tells us from 1990, none of our co-occupant consent to search cases, however, have presented the further fact of a second occupant physically present and refusing permission to search and later moving to suppress evidence so obtained. The significance of such refusal turns on the underpinnings of the co-occupant consent rule as recognized since Matlock. The defendant in that case was arrested in the yard of a house where he lived with a Mrs. Graff and several of her relatives, and was detained in a squad car parked nearby. When the police went to the door, Mrs. Graff admitted them and consented to a search of the house. In resolving the defense objection to use of the evidence taken in the warrantless search, we said that the consent of one who possesses common authority over premises or effects is valid as against an absent, non-consenting person with whom that authority is shared, consistent with our prior understanding that Fourth Amendment rights are not limited by the law of property. We explain that the party's common authority is not synonymous with a technical property interest. The authority which justifies the third-party consent does not rest upon the law of property with its attendant historical and legal refinement, but rests rather on mutual use of the property by persons generally having joint access or control for most purposes, so that it is reasonable to recognize that any of the co-inhabitants has the right to permit inspection in his own right, and the others have assumed the risk that one of their number might permit the common area to be searched. The constant element in assessing Fourth Amendment